I'm going to take a quick look at how to furlough workers, and then we're going to move into some of the key concerns we're seeing. But most recent guidance has clarified the position on employee consent. I've talked about that in passing already, so I'm not going to spend too much time on it. Everything there is on the slide, and I know I are releasing these slides to everybody, so we can read through these points at their leisure. Having said that, fundamental point is point 3 there. The latest Treasury direction now requires that an employer and employee must agree in writing, which can be by email, that the employee will cease all work in relation to their employment. So this is the express consent. So this is why I'm saying that maybe all employers need to go back and look at the knee-jerk consents they got right at outset of this scheme, the query of whether implicit consent was acceptable. And bear in mind, most advisors, myself included, were saying, certainly for the hospitality industry, when you had no choice, all you could do is write out and leave the consent piece at the bottom of the letter, the email, etc., and then ask the employee to sign and return that. So you were doing it with a degree of retrospective effect. You had no ability to consult in advance, really, for certain sectors at certain times. So for any of those employers affected, you've got to go back, check the consents you've got, and make sure that they are now compliant with the latest Treasury direction. The notice of furlough itself, just a reminder there that the communication records, everything issued by employer to employee, must, not shall, not will, must be kept for 5 years. So that also illustrates, again, if we needed a further reminder of the period over which HMRC are going to potentially retrospectively assess and seek to recoup. So my next slide then on how to select which employees to furlough. This may be academic for some businesses because effectively every employee will have to have been furloughed. But again, there's a number of flexibilities within this scheme. If the operation is only being reduced, then you default back to employment principles, which must be fair and reasonable selection criteria should be applied. Again, basic employment law applies. Equality discrimination laws will apply as normal. However, given the reason for the whole scheme, which is the coronavirus and the pandemic, which we are still in lockdown in regard to, then an employer does have to put in a degree of subjective criteria in relation to its selection methodologies. So you do have to look at the age of employees. You do have to consider whether or not there may be an underlying illness. You should consider whether or not there is any shielding, whether the employee is shielding another or lives in the same household as someone who is being shielded. So we do have to ask some of those questions and considerations. You can, if we have the ability to do so, we can also ask questions in relation to childcare responsibilities, etc., because there may be a degree of election and personal choice within furlough. And furthermore, given that the furlough scheme is being extended now to end of June, if an employer needs to stay in there, there is this concept of rotational furlough. And even if you have to make some tough selection decisions at outset, it may well be that you can soften the blow of that, because for a lot of people there will be a stigma attaches to being furloughed, and say that actually, we're furloughing you for 3 weeks or 4 weeks, but then even if we remain in furlough, I'm going to bring you back so you keep in touch with your client base, you keep in touch with certain of your colleagues, you work generally, keep your skill levels up, and we're going to furlough someone else. So you can do rotational furlough in principle. It just adds a bit more logistic and admin nightmare to those of us who are left to actually manage this, but it is permissible.